So while Marcia's putting this up, let me ask a couple questions. All right. How many people in room do capital work? Raise your hand. Nice. Okay. How many do primarily juvenile defense? Raise your hand.
Primarily, no, but we do.
Okay. I mean, and how many do both? All right. All right. Well, hopefully we're going to make everybody experts in both today. When we talk about juvenile justice and juvenile defense, the first thing that I forget, because I've been doing this too long, is that, even the name of the system, so this is Juvenile Delinquency Court, right? The first two words, come from the 19th century, basically. We're still using them. And the first court was in the late 19th century. I'm not going to do a total history lesson, but if you are not familiar with juvenile court at all, a couple of things that are good to know is that there are some holdovers over time about, it's sort of archaic and arcaneness. We'll talk in a minute about, the practice of juvenile defense, the actual concept of having lawyers represent youth in juvenile court like they would in adult court is a fairly recent idea from 1967's In Re Gall. So a lot of these ideas are relatively new and they're always evolving. Juvenile court is always evolving. Look at Raise the Age, right, which was just a few years ago in North Carolina. So a week or so ago, I was in Washington, North Carolina, and I was meeting with some folks, including Christy Stilden. Now, Christy didn't know I was going to call on her, but Christy said that the first thing I should say to those of you who haven't been in juvenile court or haven't been a lot is don't panic. And what I mean by that is you're going to walk in there, right? And you're going to be like, what in the heck is going on? Who are all these people? What language are they speaking? Why don't kids get bail? Right? And why is the judge looking at me funny? Has this ever happened to you? No. Any of you in juvenile court, has this ever happened to you? I see you laughing, John. All right. So a couple of sort of salient points about this. One is, this is district court practice, right? So what I like to say, everybody's heard me say this before, there are 100 systems of justice in juvenile court in North Carolina. Every district court is a little bit different from the other one, including within a judicial district. In our world, or I guess maybe in my world, I tend to see, how it used to be the old ways. Like we've got like 30 districts and sometimes there's A's and B's. But just because you're in one county in a district doesn't mean that's the way it runs in another county. And so that's something to take into consideration when you're walking into these courts. As I mentioned before, because of the history of this court really emanating from social work court, there can tend to be a court culture where the participants, the stakeholders tend to think that the court is one of a service court and that you're coming in there to try to help these kids. And when you talk about helping kids, sometimes you forget one thing: due process, right? This is the point of In Re Gall. What Gall did was it sort of, the US Supreme Court put its collective foot down and said, actually, a lot of these rights that apply in adult criminal court apply in juvenile court. The problem is people are slow to get the memo, right? 1967, okay? And that's not a criticism. I just think that the evolution, how this work is done, has been slow. And frankly, it's incumbent upon all of us to move that needle forward. That's a lot of our job, is getting into that courtroom and educating the court and explaining to the court what the heck is supposed to happen. With that, we'll talk a little bit about role in a minute. Sometimes the parties act differently in different courts, have different roles. You may go into some courts, and when you're having a secure custody hearing, the court counselor is arguing for your client to be in secure custody. Now, are court counselors lawyers? Am I making this up? Has anybody ever seen this happen? Yeah, that's right, right? Right, that's the job of the prosecutor, but suddenly this person over here is doing the argument. What's going on, right? What's going on? And then you have all these other people involved, and not the least of which is Division of Juvenile Justice, which I'll talk more in detail about in a minute, but sometimes you kind of see that, and that's awkward. The other thing that's difficult, especially with these cases, is the kind of hurry up and wait principle. The transfer process, which you'll hear much more about later, in juvenile court can be very, very quick. And suddenly, your client, who is still a youth, it's somebody between the ages of 13 and 17 who's been charged, and their parent, their guardian, the custodian, whoever is involved in their lives, it's hard for them to understand that they've been charged with this serious offense. This has happened. And now suddenly they're sitting for months, if not a year or 2 years, waiting on what's going on. This is all about our communication with our clients, right? You got to talk to them up front and say, okay, we might be on the train now, and then we're going to stop at the depot for a while, and we might not move forward. So all these kind of things, when you get into that court, you got to start to think about a little bit, because you may not be used to it if you haven't appeared in that court. All right. Yeah, panic spam. Okay. So I want to talk a little bit more about why we have juvenile court. Talk about the scope of representation. This is not the number one, close to the number one topic that we talk about, the role of defense counsel. I want to go in a little more detail about this different language, who's there in court, both parties and stakeholders, or stakeholders and parties, or what role does the parents play? We don't know. Talk a little bit more about resources. I know we discussed that, but, and I'm sorry, you're probably going to hear that more than once today, but we're just trying to reiterate where you can find stuff. And then a little bit of data, like, who are these kids you're representing? And then also, and this is a big one, is my kid is locked up. Where is my kid? How do I get in touch with my kid? Why has my kid moved from one facility to the other and nobody told me? Okay, what are the rules about seeing my kid? So we'll talk about that. And feel free to ask me any questions. I don't know even I'm going to take the whole hour because I tend to talk fast. And at any time in your representation, all those folks you saw standing here, if you ever have a question, and look, I know we've heard this from our parents, but it's true. There is no such thing as a dumb question in juvenile court, okay? How long have we been doing this? I mean, I've been in juvenile justice 25, 26 years. Every single week I hear something new. Some attorney calls me and says, this happened. I'm like, what? I don't know. Things operate so differently. The law tends to change. There's a lot going on in this court. So please feel free anytime to call, email, text, whatever. We will be glad to respond to you. All right. Right, the reason we have a different jurisdiction is totally based on the age of the person who was charged, who was alleged to have committed an offense. This used to be kind of easy just a few years ago, and in a short span of time, North Carolina has decided to change the law. For 100 years, if you were around 6, because that law changed, I'm good at that, but basically between the ages of 6 and 16, you were in juvenile court and everybody else was in adult criminal court, and now this is all changing. There is some complexity to it, but really for your purposes, we're just doing a flyover just so you get a sense of this. But if you also do juvenile court and you've got a question, like I said, feel free to come to us. So you see the age is now 10. This just happened a couple of years ago. So at least since the 1979, 1980, you could be 6 years old in North Carolina and charged and placed in juvenile court. Guess how many other states had the age at 6? 0. Right, we were number one on that one too. We don't need to worry about that. Now that it's changed, generally it's going to be 10. 10 years old is a minimum. Why am I talking about this? Because we're really focusing on 13-year-olds. Because it's the mentality of the court. We're trying to change the way the court thinks about these youth. And this impacts your representation because at every step of the way, we are constantly reminding the court that these are children, kids, youth, right? It doesn't matter about the seriousness of the offense. That doesn't change who they are. But I think we've done a pretty good job of starting to affect their thought about this, okay? So 10 with an asterisk, because why? Who wants to explain why 10 has an asterisk? Berger would like to explain. Tell us, Berger, why does 10 have an asterisk?
Would be charged as low as the age of 8 years old if it's something really, really serious like first-degree murder.
Right, but they can't be transferred, okay? They have to stay in juvenile court. And folks, this does happen. You know, I've heard mostly cases of 12, but I have been involved in cases where a 9 or 10-year-old was charged with a homicide. That can in fact happen. Again, when we talk about life without parole, because that's an adult criminal court, we're still talking about age 13. But if you find yourself in juvenile court and you're doing other cases, know that it can actually be as younger as 8 or 9 to be charged with murder, okay? The only other note I wanted to make here is that actually, so these are the ages generally you can start and end up in, but you can stay in a youth development center until you're 21 under certain circumstances. Why am I mentioning that? Because there might be a time where, you know, you can get a plea in juvenile court, and sort of knowing what the outside limits are is helpful, so you can talk to the prosecutor. There really hasn't been any discussion extending that time or having like what they have in some places is blended jurisdiction. But I'm hoping at some point we can do something with that so there are more options. Because right now, you know, you're looking at a very short period of time in Y Youth Development Center versus spending a large amount of time in adult criminal court. Okay. So where does this law come from? Like, how do we get started thinking about what are the legal parameters around juvenile court? And it stems first from the US Constitution. Now, before Galt, there was a case called the US. Anybody familiar with this case? Okay, so these cases that I'm putting up here, I'm not going to go into detail, but I would recommend, if you're serious about doing this work, to check them out, because there's language and information in these cases that are being used now to try to challenge automatic transfer. Kent is one of these cases. This was a case in DC where a kid was transferred and had no meaningful access to a hearing. And the US Supreme Court said, no, there's got to be some consideration of the youth and the charge. It very much goes to discretionary transfer, and it's such an influential case that in 1999, when we rewrote our juvenile code and put together our transfer factors, guess what we looked at? Something from 30 years before, okay? So it might be a good case to note. Galt is the foundational case of our practice, and through the 14th Amendment, we have these rights now: counsel, notice, confrontation, self-incrimination. There are other adult criminal rights sometimes that can apply in juvenile court, but as we discussed before, because largely you're going to start the case in juvenile court and it's going to be fairly quick, possibly, they may or may not come into play, but it is something to think about. And then also, as a broader concept, how do these rights apply to my client? We talk about this all the time. Yes, I know some of you are thinking, but not saying, that you may have heard at some point that the Constitution doesn't apply in district court. How many of you have heard this? Raise your hand. Yeah, it does. And you can cite me, and I'll be glad to come on WebEx and say, yes, Your Honor. I know. All right. So I just threw up Winship. That's actually sort of one of those lost cases, but proof beyond a reasonable doubt. Hey, yeah. Again, you're going to be thinking about that more on, you know, criminal end. Doing juvenile court, no, that does apply in juvenile court. And I just threw up JDB versus North Carolina, largely because, again, when we talk about the next series of cases, this case kind of fit in very well. If you don't know, just briefly, this was a case that came out of Chapel Hill. This was a young man who allegedly was involved in some breaking and enterings, and law enforcement came to school to interrogate him. And the defense argued that the juvenile was in custody when law enforcement was in the classroom with him. This is very much going to become relevant if you have a young person, because what's the number one evidence against our juvenile clients, folks?
Social media.
Statements.
Themselves.
How about
Yes,
they
the answer is themselves. Yes. They can come from many factors, yes. So suppression is a huge deal for us. It's a big deal in juvenile courts. In this case, kid was in the principal's office, said, yeah, I was involved. And so the case started to become about not voluntariness, but custody. And if you don't know the story, lost in district court, lost in Court of Appeals, had dissent, Justice Beasley, went to the state Supreme Court, lost 4-3, writ of certiorari, and then we won on the US Supreme Court, saying that you have to consider age when determining whether or not you're in custody for Miranda. Does this apply to searches? We're not getting into that today. But you can use it. All right. Hopefully folks know this. Did y'all get your stickers? Yeah, stickers are cool, weren't they? Whose idea?
It was Eric's idea.
Yeah, it was Eric's idea. Everybody thought that was dumb, and I said, no, I love stickers. All right. I did forget to put one case on there, but yet I didn't. So this you need to know. This is the stuff you need to know, okay? This is fairly recent. This is the lineage of cases that brought us to where we are at today in the US Supreme Court, okay? Now, there's a lot of cases before Roper too, right? Outlawing the death penalty for people with mental illness, and there's some other seminal cases, but this was the first case. The holding, of course, is not execute somebody under the age of 18. That's obviously critical. It's really critical how they got there. This is adolescent development 101. Right, Dr. Cottle? Okay. And this is where we got started talking about if you're a certain age and you're involved in the court system, you need to think about how that person is thinking about what happened and what kind of ramifications there are. And this general principle has not gone away, okay? And in fact, look at these other cases. It started to flow through other variations. Graham versus Florida. So you couldn't give life without parole for anybody under the age of 18 for non-homicides, okay? And then we moved to Miller. Miller, again, was sort of that line in the sand. Miller talks about that you can't have a statutory scheme in your state that says you have to get, there's no opportunity for parole for homicides for anybody under the age of 18. You simply cannot do that. Now, Miller didn't go into a whole lot of detail of telling us how, so we've had some federal and state cases looking at that. Montgomery, also seminal. It did take 4 years, but Montgomery was the case that allowed us, I don't know, has anybody done an MAR Miller hearing? Okay.
In another state.
In another state, okay. But Montgomery was Montgomery was the case that allowed this to happen. Like, you can go back in time now and argue that it was unconstitutional to give somebody LWOP before Miller even came down. Okay, so this is great. Now, we have had a little pushback in Jones versus Mississippi. I did not put Jones versus Mississippi on the sticker. I wasn't before court, and they didn't ask me, Mr. Zagrai, what's the relevant law in this case? I just made a sticker, and it's not on there. So what it says is that when you're determining whether or not LWOP can be granted, you don't have to make a specific finding about permanent incorrigibility. This was part of the analysis in Miller and the cases flowing that basically said that the court has to find that the youth before the court is not going to change. Okay, I don't know how they figured this out, but this is the language, permanent incorrigibility, and they say if the court finds that the client is permanently incorrigible, then probably LWOP. We're gonna get to this in a second, because hopefully, as folks know, we had a couple of cases in North Carolina just last summer that talked about this. But this language is going to be critical when you're doing these hearings. And you gotta know this, okay? Because these are the magic words that are going to be uttered and argued to try to get your client access to parole. Everybody okay so far? Great, all right. So, more broadly, North Carolina's law in juvenile delinquency court. Oh, and I'm sorry, I forgot to mention something. Stop me. Did you notice I'm saying juvenile delinquency court and not juvenile court? Or sometimes I'm slipping. Why am I saying juvenile delinquency court and not just juvenile court? Anyone?
Because there's A and D court as well.
Or in one juvenile court?
Yeah.
Like what?
Abuse, neglect, dependency.
Yeah, right? There's an entirely other court working, it's a child welfare court. We call it abuse, neglect, and dependency court. It used to be in the same sets of statutes commingled with the juvenile code. It's not anymore. But again, going back to what I said before, when you're going into a certain courtroom, guess what? They might be hearing both kinds of cases that day, that same court. Is that anybody's practice in their jurisdiction? Yeah. So why is that relevant? Well, because sometimes people mix it up in their heads as to what's going on. And that might be the same judge who at one point is hearing, a case about whether or not, a kid should be removed from their home. And now I'm hearing a case about a kid being charged with first-degree murder. Is this the same thing? No, it's not the same thing. That's why if you look on the screen, you see subchapter 2. Whitney Fairbanks at IDS is great about this. She always says subchapter 1, subchapter 2, and I appreciate that because that brings me back home to say, this is, now, the link is 7B, but you gotta look at subchapter 2. It starts at 1600 and goes to 3000 and something. Does that sound accurate? That's the body of law. Okay, I didn't bring a code, but that is the body of law. However, this is free on the internet. The juvenile code, which has both parts, if you can get a hold of that is annotated and does have cases, so there's some pluses about that, but you can find this here, and as I'll talk about in a minute, we have case law, there's different places you can find case law. Here's the case law, right? So there is not a lot, somebody disagrees with me, but I don't think there's relatively a lot of case law in North Carolina in juvenile court. We do things like litigate disorderly conduct over and over again. Okay, so not that. Lately, we've been litigating communication of mass threat or false threat. That's been a big one. Not a lot of stuff on transfer, first degree murder. Not a lot of stuff at all. It's still pretty much wide open. I don't know the reason for that, somebody else may know, but the transfer law in North Carolina, it's kind of hard to battle, and as you'll hear, the appellate process is a little tricky with transfer, and maybe that's partially why, but we just don't have a lot of cases. I want to mention both of these links. So the first one is on our website. This is an update that we provide anytime any juvenile cases come down that we think are relevant. Again, sometimes if they keep litigating the same issue and there's not a lot of different facts, we simply don't put it on there. But you also have the School of Governments link, because you might get some different impressions if you look at the way they live cases. And as Latobia mentioned earlier, Versha started doing a case law corner once a month. There is a case law corner where we either look at whatever cases came out, and sometimes there's not. I mean, sometimes there's just not any cases that come down, or we focus on a specific issue. Maybe one case law corner will focus on first degree murder. Note to self.
And we're always accepting guest blogs.
Oh, yeah.
If you have a thought, we would love to share it.
Yes, please contact Latobia or any of us if you would like to do a guest blog. We are also considering, I'm tipping the hat a little bit, but maybe doing case law corner for our upcoming regional summits. That's true, yes, I see Yolanda nodding, so that must mean it's true. Okay. Again, there's a handful of cases on transfer. There's State v. Green in 98, which goes over like the abuse of discretion standard in transfer. You'll hear more about that. In re KRB, which talks about the petition, what the petition says, and whether or not it's first-degree murder. You'll hear more about that later. But most importantly, probably the most important cases on juvenile LWOP in North Carolina just came out last summer. The Kelleher and Connor cases. Anybody hear about these cases? Okay, just a handful. Okay. These were two youth who were convicted of first-degree murder, transferred convicted of first-degree murder. And David Andrews and Kathy Vandenberg from the Office of the Appellate Defender just did a heck of a job. We got the result, and somebody correct me if this is wrong, but basically what both say is that you have a youth who's convicted of first-degree murder, and they're sentenced to life without parole, and the court does not find permanent incorrigibility. They have to be considered for parole after 40 years. Is that right? Did I say that right? Okay. This is a huge deal and a big win for us, because otherwise it could be what? It could be infinite, right? But David and Kathy got it capped at 40 years. Read those cases, okay? These are seminal cases now in North Carolina law, and they will help you craft your arguments at your sentencing hearing. Okay. There are some basic differences in juvenile court than adult criminal court. First and foremost, I think one of the things that North Carolina has always had right, this is not true in other states, is that you are presumed indigent in North Carolina in juvenile delinquency court if you're charged with an offense and you get a lawyer, period. There is no consideration of indigency. We don't know how good we got it. Yes, ma'am.
Question, I'd love to hear your thought on in front of a whole bunch of people where you can't backtrack on your answer.
I reserve the right to remain silent.
There are a number of jurisdictions where once it gets transferred, the judge will say, okay, we are considering your indigency status now, despite the fact that the child was a child at the time when charged, and it started in juvenile court. Your thoughts, sir?
I know of no law that provides for that process. I mean, one thing you could argue is until you're convicted, you're not an adult. Think about that, right? Because it can always go back. That's the first argument. The second argument is if you're the same lawyer, you're like, well, Your Honor, I've already been appointed by another judge. You can overrule that other judge. The other thing I would say is my understanding, you know, again, from hearing is that largely for youth, they were not asking about indigency and the ability. But if they are doing that and you're faced with that situation, that's what I would talk about. I would say I'm vehicle offense of some variety starts in juvenile court. This was the big deal about raise the age. It does not matter what you're charged with, including first-degree murder. So as you will hear ad nauseum today, 13, 14, 15, 16, 17, you start in juvenile court. There's not an exception. That's where they all start. Now you'll hear more about the process of how they get up, and it kind of looks a little like adult criminal court, but be sure if your client didn't start in juvenile court, something's wrong. Okay, I think we've more or less gotten that right. The indictment piece is a little fuzzy still, but I think everybody understands that it doesn't matter what you're charged with, you are starting in juvenile court. Okay. Another big difference is how and where juveniles are held. Secure custody versus bail. You do not have a right to bail in North Carolina in juvenile court. Now, hold that thought for a second. So we call this, if you're not familiar with this, secure custody hearings. Check out chapter 19. That's what you need, 7B 1900s. That's where you need to look. There are, because you don't have the right to bail, there are very, very specific rules about how you get released. And basically, it's a judge's decision. That's it. It's like having unsecured bond all the time. And you're like, woohoo, that sounds great, Eric. No, that is not great. You know, a lot of times, and I'm going a little bit off topic, but a lot of times they'll say, well, your client, you know, has been charged, you know, with a serious felony and has demonstrated they're a danger to persons or property. Well, Your Honor, my client has just been charged with something, has never been charged with something before that, so I'm not sure how they've demonstrated they're a danger when nobody has said they are responsible for this offense. Oh,
Say it louder for the people in the back.
well, you know, yes. Kelly,
You went, oh, really? Like you had an epiphany, but that is not the reaction you actually get from a judge when you make that argument.
but that's the reaction this audience is, that, you know, that's the great thing about not having to practice. You can just pretend like don't listen. But no, I mean, remember what I said earlier that you'll be hearing again? You got to talk to the court about this. This is what this law means, right? And we have to argue this to the court. So, how do we get our kids out? What are some ways some of these kids can get out? Anybody who does juvenile court?
Electronic monitoring.
Electronic monitoring, what else?
Any lesser restrictive alternative?
Any lesser restrictive alternative? Come to the court with a what? A plan, right? Give the court a plan that will reassure them that your client will not get in any further trouble and they will appear at their court hearings, okay? That's the kind of thing you need to do because they don't get bail. Now, once the judge says transfer, the moment that happens, you should be having a bail hearing. You should be having pretrial release at that moment. They're going to talk about that in detail later, but at that point, they have the right to bail, and then you can start discussing that then. So what you may want to do is be thinking about this on the front end. That's another main point about this training, is a lot of the stuff in your representation that you're doing sometime down the road, you got to start thinking about early. You got to start prepping early. So this is one of those, because it might be like, oh, we came down with an indictment and it looks like a true bill and we're going to transfer your kid. What do you think about pretrial release? Madam Defense Attorney, you know, Mr. Defense Attorney, what? You know, be ready for that, okay? We'll talk a little bit more about where your client is in a minute, but know that that's a difference. Another difference that, again, you're going to hear quite a bit about today is, and I know anybody who's represented anybody who has parents or guardians are going to be like, yeah, we know, Eric. It does look and feel differently in juvenile court with parents and guardians, okay? Parents or guardians can be supportive or they can be highly detrimental to your case. It is very difficult navigating this. It's very difficult. And I wish I had all the answers to that, but I don't. I'm sure somebody does. But especially in juvenile court, when you're starting, there's going to be a lot of questions. And why is this happening? And why aren't you doing something? And I've heard this, that, and the other, and this is how it works in juvenile court. It's hard. Okay. Scope of representation. Does anybody find this strange? Anybody find this strange or confusing? You do find this strange or confusing? Yes, you nodded.
Because in adult court, you're advocating the best interests of your client, and it's really weird to tell the judge like what crazy shit your 15-year-old wants them to hear.
Okay, that's true. Yes,
How can somebody under the age of 18 possibly know what's best for them?
right.
So it's express interest.
Well, if you do any work in juvenile court, we'll talk about stakeholders in a minute. It's everybody else's job to do that. In theory, your job is to listen to your client, is to inform your client, is to the best of your ability, make your client understand what in the heck is going on. I know that is a very heavy ask in this context because they cannot contemplate spending the rest of their life in prison, possibly. That is beyond their contemplation. Okay. And there are so many people talking to them about what they think is going to happen. or what should happen, or what happened to somebody they know, or what they thought happened to somebody they know. This is very difficult, but this is your main job, is to be that person. Now, there's a lot of folks outside of our community who do appreciate this. Not the least of which I know are the folks in the detention centers, where your client's gonna be spending a long time before they're 18 awaiting trial. And they appreciate it because you're the one telling them the truth. And they can work with that. They don't want people telling them other stuff, that, oh, you're just gonna walk out of here, or just ask for $1,000 unsecured bond, you're gonna leave, or whatever it is, okay? People appreciate this. But there's gonna be so many people around you who say, why are you doing this? Why are you challenging? My job is to protect my client. Like we've said in some of the other trainings, right? You know, they try to define juvenile defense in a sentence, and my response is, we try, you know, to prevent our clients, you know, entry into the court as much as possible. System. We try to protect them from the system. I know in this context, that's a lot more difficult, but it's the same thing. None of this changes, right? This doesn't change from when you represent adults. Don't worry about it. If somebody gives you flack about it, please have them call us, and I'll be glad to talk to anybody about this. When our office first started in 2005, this was the first piece of policy we asked the IDS Commission to approve, because we knew one day we would be 18 years, 19 years later, we would be standing in front of some folks who were strong enough to represent kids charged with murder. See, I knew that back. No, I didn't know that. But we knew it was going to be a foundational principle, and we still adhere to it today. And anyway, hopefully this is not crazy. Capacity to proceed. This is an interesting topic. I won't go over it in large detail, but it's the same thing again. Have your client evaluated. I don't know if Dr. Cottle is going to talk about, just maybe a little. So this is just like in adult criminal court. You can bring it up at any time, right? So don't be afraid to do this. Okay, you might be thinking, well, it's 14-year-old. Yeah, I mean, they're not going to understand what's happening, but do they not understand to the extent that they cannot, you know, understand your role and the charges before them and all that? Still applies. All right. We're gonna have a quiz on this, folks. You better be paying attention. I'm gonna block some of this out. Wait. What's, you know, no. This is something you ought to know if you're not in juvenile court, because people are gonna be speaking a different language. It is not all that complicated once you get down to it. And sure, some of you might say, which jail is my client being held in? This guy seemed to know. When are we set for trial? You know, and some people may give you kind of a funky look, or where's the warrant? This is gonna help you. This is gonna help you walk these steps, because then they'll be like, okay, well now I sort of get where you're coming from. We have different terminology because it's a different thought process, right? It's a different idea. Because they are young, because they are developing, they have the benefit of being in this court and us considering them different than we would consider people who are 18 and older. That's why we do this. We don't do this just to exclude people or to be smart. Thank you. It's going to be funny on the recording. Maybe I'll have to do a voiceover. Hello, I'm doing this again. No. But that's why this is relevant. So it's not just like, oh, this is a nice thing. Please sort of get to know these terms. And if somebody says something and it doesn't make any sense, you know, feel free to reach out to us to look at our resources. Okay. Parties. This is a little piece of a juvenile petition. That's the charging document. Obviously, the youth charged is number one. the alleged victim is involved. Marcy's Law does apply in juvenile court, by the way, and you may want to get to know that a little bit. Remember I mentioned before the parent, guardian, or custodian? Why do I have them on the parties slide, and why do I have a question mark next to them? Anybody? Yes.
Yeah, because sometimes the parent might not be the actual person that's taking care of the child. It could be they could be in DSS custody, it could be a guardian, or it could be somebody else. But under the statutes, the appropriate party that's in the position of guardianship needs to be the one that is noticed so that they can attend the hearings.
Right, right. Do the parents have rights in juvenile delinquency court?
Yeah.
Dustin did this. Yeah, it's a little weird. It's not really well stated what the role of the parent is. The court can order the parent to do stuff, but does the parent have any rights to do this, that, or the other? I think it really starts to come in beyond the scope of this discussion, but comes in when the court, and yes, this could happen in a first degree murder case, the court could try to order the kid into DSS custody. It seemed kind of weird in one of those cases, but it could happen. But anyway, again, don't panic if you're not sure what's going on with the relationship with the parent, because sometimes we're not really sure what happens. But again, if the case gets transferred quickly, that piece becomes less of an issue. Other stakeholders in juvenile court, prosecutors, assistant district attorney, maybe the elected will handle the case depending. Juvenile court counselor, okay. We could do a whole session just on this. Juvenile court counselor handles the following roles. They are responsible for determining whether or not the petition, the charging document, comes to court. That's number one. Number two, they provide intake services to determine whether or not the petition comes to court in the first place. They then come to court and talk about, the court will ask them, what is your opinion about the client in custody? Can you give me some history about this youth, okay? And then if your client stays in the juvenile court system, they provide the dispositional report. They are also the probation officer. They are also the post-release officer. They handle a lot of roles in juvenile court. Get to know the court counselors given jurisdiction because they interact a lot and they hold a lot of power in the process of the cases. Another quick note, and again, this could be for some other day. There's some things that they could do that they may not be doing, like diverting cases. Can't defer first degree murder. Sorry, folks. I know some of you were hoping I would say that. No. But if you do other work, they actually can divert some reasonably serious cases from coming to court and going to adult criminal court. Story for another day. There is a litany of other folks who might be sitting in that courtroom. Mentioned DSS, mental health, school counselors, foster care, other placement. I mentioned before, getting to know your detention folks, okay? This is critical. And if you don't know who's in the courtroom and you're like, what is their role? Why are they here? If you have somebody you can trust locally, talk to them, but if not, contact us and we will help. And of course, law enforcement, generally, law enforcement, I think, works these cases the same way. Your discovery is coming sometime in the future and it's an ongoing investigation and all this kind of stuff. Oh, I'm getting a little bit into the law, but speaking about discovery, are you all talking about discovery? Somebody talking discovery? Okay. Side note, discovery should flow through the prosecution. How many of you are in a jurisdiction where discovery flows through court counselor's office? Yeah, it does happen. So just a little bit of a tip. On the front end, if you're not getting the police reports, your client statement, other stuff, you may want to ask the court counselor, do you have that? Because you get access to all their information, yes.
Now with their new digital request method, it's really, really easy to get the records, and a lot of times they do include all those reports in there.
Right.
You can get it before the prosecutor sometimes.
Right. Okay, I know we've got 5 minutes and I want to stay on track. I also had these slides. You're gonna see this a million times. Hey, there's our website. I just sort of clicked on that and you can see there's a lot of materials for defenders outside of first-degree murder, but if you're looking for something specific, we have motions, forms, all kinds of training stuff on other topics. We have information on the juvenile rates that just changed. And as we discussed, the defenders portal, and that's the specific link. All right. Are we saying, we already said it out loud. What is the password to the defender portal?
OJD defense.
OJD defense. OJD defense. Yes. There's other places you can find resources. Whoop. The IDS website. Check out what OCD and the Office of the Appellate Defender has. They might have some briefs or other information that can help your arguments. So check out what they've got. If you want to know more about juvenile justice, that's their main site. If you want to try to contact somebody there, again, we might be able to access that information sooner, but if you need to find a court counselor, a chief court counselor, a regional administrator, you need to talk to the head of detention, whatever. That information should be there, but if it's not readily apparent about what you need, contact us and we will walk you through it. The facilities link though is key, and that's probably, I think, the sort of the last thing. Well, almost last thing. So, and maybe this should have been sooner up, but we're always asked, like, how many kids are being charged? Okay, first of all, it's a lot less than in the adult system, but it might be more than you think. We know from the data that we've seen that there's largely about 100 youth between 13 and 17 charged per year. It's something like 8 per month. Thank you, the folks at the Office of the Capitol Defender that are letting us know, and we're building a database on who's been charged. It's pretty clear that at least 3/4 of these folks are the 16 and 17-year-olds. That's probably not a surprise. But sort of to know that and to think about what might be different from the 13 through 15-year-olds. And again, this should be no surprise, 85%. And so the last, we tried to get specific data on youths 13 through 17 who were charged with first-degree murder, but we didn't quite get that in time. What we do have is we know that 85% of the youth transferred now are youth of color, 68% African-American. So this is the population that we're representing.
Eric, I got a question.
Yeah.
Are we able to find out what county most of these juveniles are being charged in? Is that, if you know?
Mecklenburg.
Okay.
I had a slide on that and I should have brought it. Largely, I'm gonna say it, I'm gonna be wrong, but yes, get to me later and I'll let you know. It is not, for those of you really interested, on the juvenile justice website, there is a breakdown called county data, right? County data books. The county data books break down demographics, ages by county. They don't break it down by offense. And so you can see, I think they may do like serious offenses, low-level felonies and misdemeanors. So that might give you a sense of where it's happening. But if you want something more specific, let us know. We're always asking DJJ for information. They're very good at getting it to us. All right. Last thing, and maybe the most important thing. Where is my kid? All right, right? The vast majority of these kids will be in confinement. Notice I'm using the word confinement, not jail, right? Because part of the post-raise the age package was, and I think this was a good thing, that if you are under the age of 18, you are going to be in a juvenile detention center, period. Even if you're transferred. Say that again. Under the age of 18, even if you're transferred, you're going to be in a juvenile detention center. Now, I've listed all the juvenile detention centers, I think. I might have missed one. Anybody notice anything? How many jails are there in North Carolina?
A lot.
Yeah, a lot more than that, right?
At least one per county.
Yeah, this is tricky because these kids are being held possibly very far away from you, okay? That's thing number one. Thing number two is that, they may, when you start with representation, you have your first secure custody hearing. If you haven't been able to see your client first, ask them where they are being held. Contact that detention center. And just ask, normally they should be able to let you all in at any time. We have heard very recently that there might be a concern about the identity of the attorneys, so bring your bar card. I don't know that I would go so far as to bring your order of appointment, but just be aware that this might be happening. If you have a question or concern about that, contact us. It should be okay. But this has just popped up recently, and we talked to juvenile justice, and they were like, we're trying to get a policy together. But counsel was largely, hey, if you're the lawyer, you can show up whenever. Yeah.
Some of the detention facilities, Alexander in particular, are telling attorneys that they have to have the client's parents sign a release or verbal authorization in order to see the clients. I was able to confirm that last week.
Can you repeat that? Okay.
I know that that might be an issue.
Okay, so I don't want to say that's not right on TV.
I'll say it for you.
No, so if that happens, there's a couple of routes. One is you contact the director. If the detention center director's like, yeah, that's what we're doing.
Can you repeat the scenario?
Okay, so the scenario was that you go to the detention center and you're the lawyer. And the detention center says you actually, the parent has to sign a release for you to be able to see your client. That's not true. Alright, so yes.
Well, I have another scenario. In Dillon specifically, you have to give them 2 days notice before you can see your juvenile.
Okay,
So it's-
yes.
And the woman you talked to is out a lot.
Oh, yeah, I'm not gonna say her name, but, if this goes for everybody, if you have juveniles in Dillon, CA Dillon, you have to give them 2 days notice before you see your juvenile.
And then you may still not see.
Yeah, and then you may still not see.
And you may drive all the way there.
Yeah,
Maybe turn.
Okay.
Yeah.
So a couple of different things happening. To the most recent point, one of the reasons for that, if you haven't read about this, is they don't have folks to run the detention centers. And if you don't believe me, ask the Lassiter, the director who was going and working at Cabarrus County Detention Center, which helped believe it, it's bad. That's part of it. I'm not saying that's an excuse. And we've talked to them and everybody kind of knows what the deal is, but we've been told that there should not be a barrier. About Alexander, again, director, if the director doesn't comply, I would probably talk to the director of facilities, and if you're still having trouble, let us know and we will contact DJJ and see if we can do anything. Yes.
I had one in Alexander up until a couple months ago, and that came up. And, but we did get it worked out before I had to leave or redo. They went up the chain somewhere, somehow, came back into the room and let us in.
Okay, well, that's good to know. But that should not have to happen.
Excuse me,
Yes,
when someone is speaking, lots of times we can't hear what they're saying. Is it possible for the presenter to?
repeat the question. So what he was saying was that he had a client at Alexander where the same policy had been implemented like midway through the process, but that the issue ran up the chain somewhere and it did get resolved. But the main takeaway here is if you're having a problem, please let us know. I know we've helped different people. And Cole, I'm reaching out to you here. Another point I want to make before we wrap up. Cole had a client who was far away. And he asked the court, made a motion to have the client moved, and
Court granted it.
the court granted the move, okay? That might become an issue for you. See where these are located? There's no law on this. There's no policy that we're necessarily aware of. But if it becomes laborious, let us know, and we will share that motion and try to help you get your client closer. We cannot promise this, but we will try. All right, it's 5 after. I am going to wrap up and say thank you. Thank you for coming. Thank you for staying. Thank you for listening. Thank you for doing this work. Again, I'm not trying to recruit, but if you're interested in doing this, drop us a card, let us know, and we will keep you updated with how the direct appointment is going. Thank you again.